Let me just start by thanking Margot and Heather and Jack for putting the conference together. And thank you for waking up so early on a Sunday to get to this panel. We're going to be talking about location tracking and the right to privacy and the Supreme Court's decision in Jones. I'm going to let the panelists do most of the talking, but I thought it might be useful just to start by setting out a few of the questions that I hope we can address or at least touch on in the next 90 minutes. So let me set these questions out and then I'll introduce the panelists. So first, how worried should we be about the proliferation and increasing technological sophistication of location tracking technology? Chris's extremely useful presentation sort of starts from the premise that this is something we ought to be worried about, but it might be worth just thinking through why it is that we should be worried about this technology. Second, in what circumstances should location tracking be a concern of the Fourth Amendment? And in particular, should it matter what technology the government is using or how efficient or inexpensive the technology is? Should it matter whether the target's location information is obtained directly or through a third party? Should it matter whether the tracking is invisible to the target? Or to ask that question in a slightly different way, should it matter whether the target has notice, either contemporaneous notice or delayed notice of the surveillance? Should it matter whether the government is making a permanent record of the information it's obtaining through the surveillance? Or should it matter how the government intends to use the information that it's obtaining? And then should it matter whether the surveillance is individualized or generalized or dragnet surveillance? Chris drew that distinction between obtaining information about the location of a particular person and on the other hand, asking cell phone companies to disclose all of the numbers that were in a particular vicinity at a particular time. And then should it matter how precise the surveillance is or the degree to which the surveillance is automated rather than directly controlled by humans? And then finally, and this is something that I'm sure we will talk about, should it matter whether the surveillance required a physical trespass? I think that maybe the last question I'll just identify is if location tracking should be a Fourth Amendment concern in some circumstances, and obviously the Supreme Court has now held that it is, what follows from that? What protections should kick in and when should they kick in? So with that, let me introduce the panelists. First, on my far right, Scilla Smith is a senior fellow at the Information Society Project here at Yale. Prior to joining the ISP, she was an attorney with the Center for Reproductive Rights for 13 years. She writes about privacy, reproductive rights, and the Information Society. Judge Kaczynski, as everyone already knows, is a judge on the U.S. Court of Appeals for the Ninth Circuit. He was appointed to that court by President Reagan in 1985. He's written eloquently and powerfully about the right to privacy. Unfortunately, much of that writing has been in dissent, but maybe that will change post-Jones. And I'll skip David for now. Susan Freewald is a professor, I'm coming back to you, is a professor at the University of San Francisco School of Law. She has published widely about cyber law and information privacy and has authored or co-authored many amicus briefs in cases involving the electronic surveillance laws. And then David, last but not least. David Gray teaches criminal law and criminal procedure at the University of Maryland's Francis King Carey School of Law. He's written about retributive justice, transitional justice, and of most direct relevance to our discussion today, about the Fourth Amendment. Some of what he's going to talk about today is based on a collaboration with Danielle Citron, one of his colleagues at the University of Maryland. So I skipped David because he's our first speaker. He has very kindly agreed to provide a kind of summary of Jones so that we're all starting in the same place. So we will begin with him.
And I promise that the brilliant bits of this are all from Danielle, and any mistakes are entirely mine, but don't report back to her. So in This time last year, the United States Supreme Court, in a landmark non-decision, nearly held that we have a quantitative interest in privacy under the Fourth Amendment. The facts in Jones by this point are well known. Mr. Jones was tracked by law enforcement officers in Washington, D.C. over the course of 28 days using a GPS-enabled tracking device. And in the course of that surveillance, officers gathered over 2,000 pages of data and were able to monitor his comings and goings on private streets for an entire month. And the question presented to the court was, is this a violation of his Fourth Amendment rights, which, as most of us here know, turns out to be a question about whether he had a reasonable expectation of privacy. And 5 justices of the Supreme Court, writing in concurrence, would have held, had they had the chance, that Mr. Jones had a Fourth Amendment reasonable expectation of privacy in the quantity of that data, which is to say, as Justice Alito suggested in his concurrence, that he had a reasonable expectation of privacy in the totality of his movements over public streets for 28 days, even if he did not have a reasonable expectation of privacy as to his movements over public streets for any particular afternoon. The amount of information matters. And this is what's come to be called the mosaic theory of Fourth Amendment privacy, which is to say that when we aggregate certain quantities of data, a magic threshold is passed, after which we have a Fourth Amendment reasonable expectation of privacy that the government, at least, and hopefully nobody else, would gather that much information about us. A little bit, fine, but not too much. As I suggested a moment ago, that was not the holding in Jones, rather that was the threatened holding in Jones. The actual holding in Jones was based on trespass, because unfortunately these officers violated the terms of a warrant they'd been given and effected a physical intrusion upon Mr. Jones's car to install the device. And that was the centerpiece of what turned out to be the majority holding. But nevertheless, the shot has been cast over the bow, and Danielle and I really feel that we are in 1967. In 1967, the United States Supreme Court was confronted with facts that nearly required it to overturn Olmstead. Olmstead, of course, mentioned earlier, is the famous case where the court said that there is no violation of the Fourth Amendment if law enforcement officers install a wiretapping device and listen to telephone conversations, as long as installation of that device does not involve a physical intrusion into the home. In Katz, the court was confronted with a circumstance where conversations had been listened to, not with a wiretapping device, but with what was cutely called an electronic ear attached to the outside of a public phone booth. And the court announced that the principles underlying Olmstead had been cast by the wayside of history, but nevertheless did not directly overrule Olmstead itself. Which is to say that as of 1967, the court said, if you bring us a wiretapping case, we're going to say that wiretapping violates the Fourth Amendment. You need a warrant to do it. And the very next year, before that case made it to the court, the legislature came forward with the first iteration of the Wiretap Act, and to my knowledge, Olmstead has never been overturned on its facts. We think we are in exactly that same time now, in that same posture now, with a series of surveillance technologies, some of which Chris has described in his presentation. And so the question after Jones is how to make sense of that feeling we have that we have a privacy interest not to be watched all the time, particularly by government. What's the doctrinal pedigree of that feeling? Is there a Fourth Amendment foundation that we can rely upon? And if there is, how does that feeling get translated into a practical set of procedures and policies that can be implemented by legislatures, executives, and courts in a predictable way that doesn't lead to a whole host of difficulties for our poor Article III friends? And we're going to answer all of those I'm going to answer all of those questions for you in the next 5 minutes, and then I'm going to tell you what counsel in Maryland versus King should have said in response to some important questions in the oral argument earlier this week. And in a moment of obvious obsequity to the chair, I'm going to explain why the Supreme Court got it flat wrong in Clapper. Here we go. What is the Fourth Amendment all about? From its inception, the Fourth Amendment is creating a bulwark against the natural rise of a surveillance state. Law enforcement officers, as Justice Jackson tells us in Johnson, are engaged in the often competitive enterprise of ferreting out crime. They want to get the criminals, and that's a very good thing. But they want to get more criminals, they want to do it with less labor, they want to do it more efficiently. And this puts law enforcement officers on a teleological path towards a surveillance state. They're going to take advantage of every opportunity they can to increase their surveillance capacities. Pushing back against that natural teleological impulse is the Fourth Amendment, which tells us surely law enforcement officers are entitled to engage in reasonable searches and seizures, but they are not allowed to engage in unreasonable searches and seizures. And unreasonable here is defined by the interests of the people as against that unreasonable search. That privacy doesn't appear anywhere in the Fourth Amendment, but the court has been very clear, at least since United States versus Katz, that the real rights interest, the Fourth Amendment interest underlying that prohibition against unreasonable searches and seizures is a privacy interest. What kind of privacy interest is it? Well, it's been difficult, of course. Oh, I'm terribly sorry.
No, it's okay.
It's been very difficult to give a clear articulation of what that privacy interest is. But in our interest, in our view, it is simply this. We have the people of the United States have an interest embedded in the Fourth Amendment not to live in a surveillance state. And so the Fourth Amendment, as enforced, ought guard against the natural rise of a surveillance state. And there are good foundational reasons for thinking of the Fourth Amendment in this way, and Daniel and I have elaborated them, but the two that I'd like to present to you now, and we'll talk about at great length, I'm sure, for the rest of the day, are a basic liberty interest in not being watched all the time. There is an effect on us in being watched. It's not just creepy, but it limits our capacities for ethical self-exploration, for ethical self-development. It limits our capacity to develop ourselves as persons and as citizens. And therefore, there's also a democracy interest in not living in a surveillance state, which is to say that it's impossible to have a thriving democracy where ideas compete and political views are developed and expressed if the government is watching us all the time everywhere we go. And so the Fourth Amendment is the primary constitutional tool to preserve those liberty and democracy interests that are behind our interest and our privacy interest in not living in a Fourth Amendment surveillance state. What then does this tell us about cases like Jones? Well, as Danielle and I argue, it's wrong, just wrong, to think about these privacy interests on a case-by-case basis, looking at how much information law enforcement has gathered on us in a particular instance in a particular investigation. Rather, the concern at the surveillance state is one that is, I'm going to shortcut a little bit and just say, almost collectively held. It's our interest not to live in a surveillance state. Surely it's mine individually, but it's ours together, surely. And what we're worried then is about the unfettered access of law enforcement to certain surveillance technologies. There really is no surprise here, right? What is the prohibition against unreasonable physical search and seizure, including kicking down our doors and looking through our bedside table, all about? Do we prohibit law enforcement officers from effecting physical searches of our homes? Of course we do not. What we do forbid them to do is go wherever they want, whenever they damn well feel like it. The unfettered access to physical search is what the Fourth Amendment prohibits and guards with the warrant requirement. We're not proposing anything more radical than that, which is to say that we should identify the kinds of surveillance technologies that have the capacity to facilitate broad and indiscriminate surveillance, and those technologies should come under Fourth Amendment control. What does that mean? Nothing more than we know it's meant since 1967, which is that courts or legislatures or executives should come forward with constraints on access and use of those surveillance technologies that will affect a reasonable balance between the legitimate law enforcement interests at stake in those technologies and the privacy interests threatened by those technologies. With that in the rear view mirror, I would like to turn now first to Clapper. And how much time do I have? Jamil?
2 minutes.
2 minutes. All right. I'm in good shape. I'm going to first talk about Maryland versus King then, because
You should definitely get the Clapper.
Counsel for Clapper can defend himself, or he can extend my time in order to affect his interests. So Maryland versus King, which was argued in front of the court earlier this week, deals with a bill in Maryland that allows law enforcement officers to take DNA samples from individuals who are merely arrested for violent crimes, and to feed those DNA samples, the results of those DNA samples, into both a state and federal database. They also take the entire genome that's taken out of that sample and give it to a series of health record databases for scientific research. And we don't have any difficulty in finding that this kind of DNA testing technology, and particularly the integrated sharing of DNA testing results, is the sort of technology that would facilitate broad and indiscriminate surveillance. And so if you grant me this, then the question is, how do we effect a reasonable balancing of competing interests behind this kind of policy? And in order to demonstrate how this balance might be affected, I want to give what should have been the answer to a couple of questions that were given to counsel at Tuesday's argument. Justice Ginsburg. But these are all cases. I mean, the dominant use is to solve what they call cold cases. Yes, Your Honor, that is precisely the primary use of this technology. It serves legitimate law enforcement interests in solving cold cases, catching people who have not been caught and convicted, and also for releasing the innocent. Question. But your argument would not be so limited, would it? Under your theory, there is no reason you couldn't undertake this procedure with respect to anybody pulled over for a traffic violation. Well, Mr. Chief Justice, in fact, there is, because that would surely affect an unreasonable balance between the competing interests at stake in this kind of technology. To allow us to take samples from anybody and everybody would surely err too far on the side of law enforcement interests and facilitate exactly the kind of surveillance state that the Fourth Amendment is designed to prevent. Therefore, we've struck a balance at the center somewhere by allowing us to take samples only from people who have been arrested. But if it's just to solve cold cases, which is the way you started, then it's just like searching your house to see what's in your house. That could help solve a cold case, couldn't it? Well, surely it could, Your Honors, but as we all know, the warrant clause stands between law enforcement officers and physical searches at homes because that provides a reasonable balancing of competing interests that are at stake in that search technology. We think that the legal constraints on access and use to DNA technology affected by this law provide an equally valid balance. Sorry, I have to skip back and forth between the record.
Are you doing your right answers or the ones?
I'm saying my right answers.
Oh.
Question, which is, there is something inherently dangerous about DNA collection that is not the same as fingerprinting. Exactly right, Justice Sotomayor. Fingerprinting is not DNA. There is infinitely, literally infinitely more personal information embedded in our DNA than there is in fingerprinting. And so DNA testing is different, which is why if I were writing this law, I would say we ought to destroy the samples immediately after their use. Justice Kagan, the future is very close, isn't it? The future is here. And so it is incumbent upon legislatures, executives, and the courts in combination to come up with reasonable constraints on access and use of this kind of technology while recognizing and preserving the legitimate law enforcement interests that surely are served by technologies like DNA identification, GPS-enabled tracking, and so forth. Sorry, Jamil. Thanks for the extra.
Sure. Yeah, you know how much I want you to get to Clapper, but maybe we can do that in the Q&A.
I would love to do that in Q&A.
Yeah. Okay. Scylla, I hope you have had lots of coffee this morning and can.
Working on the
all
Diet
right.
Coke.
You need, yes. Yes. How's that? Good? Okay. Wow. That woke me up. If the Diet Coke didn't, David will. Okay. I have three sort of stories to tell, so I'm going to try to tell the three stories within my 10 minutes, I think. Let me say first that given my background, which is in the reproductive rights world, the thing that was most fascinating to me about the concurring opinions in Jones, although I find the physical trespass thing sort of interesting for separate reasons, but the most interesting thing to me about the concurring opinions was the difficulty they had in saying what exactly is wrong with this GPS thing. It seemed obvious to them at oral argument. As soon as Justice Roberts extracted an affirmative answer to the question, you mean you could put this tracker on all of our cars and track us everywhere? And the government lawyer said, well, yeah. And so that it was obvious at that point that the court was going to strike this thing down come hell or high water. They just didn't know how. As Walter Dellinger said at a conference that some of us were at recently, it was as if they were saying, this can't be doctrine to follow. Now, they were like this at oral argument, but they were also a bit like this in their opinions as well. And my contention here today is that although I think the concurrences fail as models of clarity, there is a rule that we can use to guide evaluations of surveillance techniques in the future, and it's just a heartbeat away. But first, to do it, I think we have to resist an overemphasis on the mosaic theory, or the aggregation theory, as David puts it, to determine when a reasonable expectation of privacy has been violated. An overemphasis on mosaics has two impacts. It results in an overly narrow view of the justice's privacy concerns. And second, it serves to obscure the important role that original principles played in limiting the reach of the rule that they're setting out. So the failure to see these limiting principles in the concurrences has led to significant anxiety among the prosecutorial community and their chief defender, Oren Kerr, particularly. Maybe it's just his anxiety, but there's anxiety about how this rule will apply to future surveillance techniques, and a concern, this is the most surprising to me after reading the opinion, a concern that the Jones ruling and mosaic theory will be applied to limit human surveillance by individual officers themselves. So the point of, and I've written a paper, a bunch of us were at this conference, so I've written this paper for the North Carolina Journal of Law and Technology, in which I go into this in more detail. But what I'm trying to do is provide a path forward. I think it's a path that the court wants to follow and needs a little help in following, and I think it's also the right path. The end point of my article and this thing, it's a little self-serving because it's a rule that we proposed in an amicus brief that we filed. But I think it's the proper rule, and I think the court wants to get there. But the end point is a rule that's both broader in some ways and more limited than the mosaic theory alone implies. It's broader in the sense that it finds surveillance intrusive not just where the technology collects a mosaic of information, a mosaic being, as David described, something picks up individual tiles of information and creates a broader picture of you, but also where the surveillance technology chills expression of constitutionally protected behavior that can take place in public with other people, but is nonetheless private. Now, I just want to take a little break here to advocate for something to those of you who are lawyers in the group, which is not to be too lawyerly, to take a step back from your overdetermination of terms and terminology, and to think more like a poet sometimes when you read these things. So when something says it happens in public, that doesn't mean it's not private. And you know, this is, I think, a problem that lawyers also have. It's a problem we have with this term reasonable expectation of privacy. Nobody can really figure out why that doesn't mean if the thing is happening already, then you no longer have a reasonable expectation of privacy in it. Well, that's just ridiculous. I mean, of course, the general warrants were happening, but they were the purpose of the Fourth Amendment. So it's not a reasonable expectation in that it's not going on. It's what we should reasonably expect to be limited to, to control about ourselves. So, okay, I'll put that aside. I know, I only have 5 minutes. Okay, so the first point that I want to make, okay, I'm just going to go straight to my first story, which is the holes in the mosaic, and why I think there are holes in the mosaic, and it's important to see them. And to illustrate these holes, let's start with a scenario that I think is more inclined to capture the fancies of a younger generation than our old references to 1984. Imagine that Chancellor Palpatine, the Star Wars character, and virtuous senator from Naboo, who is really the evil Darth Sidious in disguise, sets out to discredit the Jedi and their Senate supporters so that he can monopolize power. He orders a tracking device that relays information back to giant computers that produce, does it relay information back, Chris? No, it doesn't. See, okay, it collects information from yes, okay. I have to correct that in my paper now because I got the technology wrong. Anyway, so he puts these tracking devices on all these people and he follows them. He discovers Anakin's relationship with Senator Amidala. He discovers that Obi-Wan buys cartons of death sticks despite actually being a spokesperson against them, right? And he also finds out that Amidala, despite her relationship with Anakin, actually frequents a lesbian bar called Sisters with some of her more attractive friends from the planet Naboo. He also finds out that Mace Windu and Yoda take out their spaceships and speed through Coruscant's back alleys for fun, and he uses all this information to undermine his targets and turn them against each other. All the characters resist his blackmail except for one, Anakin, of course. This all may seem far-fetched. After all, Jedi are trained in the ways of the Force. But here on planet Earth, the Supreme Court has acknowledged that history, and most recently Anjali Dalal actually has done this too, even though the Supreme Court hasn't acknowledged it yet. But history and Anjali Dalal abundantly document the tendency of government to view with suspicion those who most fervently dispute its policies. And given our history and some current practices as well, it's not difficult to imagine, for example, an administration devoted to a culture of life, targeting the staff attorneys at the Center for Reproductive Rights, hypothetically finding out that 50% of them are gay, 30% are Muslim, and one of them has fathered 3 children by 3 different women. These are all hypothetical examples. They use the information in various ways to undermine the center's litigation and public education efforts. On the other side of the aisle, perhaps President Obama and his administration track Paul Ryan during the campaign, and they track a number of them who are of his staff members who are pro-life, and they discover that Paul Ryan works out at a gay gym. His staff members visit abortion clinics during hours when procedures are performed, no protests are underway, and the administration uses this information to discredit them with conservative constituents. Okay, so these are realistic, I think, in my view, scenarios. And let's look at how the Mosaic would look at these things. The Mosaic does do some good work here. It connects not only Amidala's relationship with Anakin, but also her visits to the lesbian bar that she's not told Anakin about. So it might be worse than non-aggregation. If you have this aggregated information, you have more material with which to blackmail Anakin and turn him against Amidala. But the Mosaic doesn't tell the whole story. An aggregation of all this data isn't the only problem, and it may not even be the most important problem with GPS or with this kind of surveillance. The most common examples of the technology's intrusiveness involve the possibility that certain information will be obtained, information that can be obtained just by discovering one trip to the gay bar or one trip to the abortion clinic. And in fact, the concurrences, although they lean on the Mosaic concept, they don't fully embrace it. They don't cite to the Maynard decision, the lower court decision in the case itself, which has an incredibly persuasive, to many of us, discussion of the Mosaic. They don't cite to Judge Kaczynski's also incredibly persuasive and eloquent dissent. I'm not sucking up here. But it was widely quoted in the briefs, in amicus briefs before the court. They make no reference to it whatsoever. And they don't cite at all, strangely, to Maynard on that point, on the Mosaic point, which is odd. So I said, something is up here. And I looked at Sotomayor's concurrence, in which she talks about the New York State case, People versus Weaver, and she quotes from that opinion where they talk about the discovery of trips to a psychiatrist or a plastic surgeon, an abortion clinic. She talks about the indisputably private nature of these trips. And then she makes a significant move beyond mosaics when she suggests that a more fundamental change to the jurisprudence should be considered, to reconsider the third-party rule. And, oh dear, I have 1 minute. And she questions the notion that secrecy is a prerequisite to privacy at all. I think Alito also makes very little use of the Mosaic concept, also doesn't quote to any of these decisions. And he says, the best we can do in this case, he sort of throws up his hands, is to apply existing Fourth Amendment doctrine and ask whether there's a degree of intrusiveness that's been violated. Now, so this is why I think that actually the rule that they're pointing to here is a broader rule than the mosaics. So let's move on to my second story. Can I? No, I can't. But what I will say is that at the end of the day, if you go through the oral arguments, it's actually very interesting. You can see the justices, the concurring justices, pick out the two principles that in the end they're going to rely on. And Breyer talks about how what we're trying to do here is to figure out what's the difference between human surveillance and 24-hour GPS surveillance. They come back to this over and over again. And at the end, they rely on two principles. And this comes up in the oral argument, and then it's in the opinions. When the normal resource constraints no longer apply to surveillance technology, the Fourth Amendment requires that abuse must otherwise be constrained. And this is in the concurrences as well. And then, as Justice Justice Breyer refers to.
Fond memories.
I know. He talks about the harm of living in a surveillance society. He says, take it backwards. What should a democratic society look like? And what the court comes to is that a society, the harm of living in a society where technology is used to follow you all the time is the enormous chilling effect that will have on people, on people's associational and expressive behavior. As Justice Sotomayor says, awareness that the government may be watching chills associational and expressive freedoms, and the government's unrestrained power to assemble data that reveal private aspects of identity is susceptible to abuse. So these are the two things they rely on. It limits the ruling on mosaics to not human surveillance until we have a clone army, at least, that can follow everybody around. Human surveillance is not susceptible to the type of abuse that they're talking about. So, or incurs concern about human surveillance is sort of, we deal with that very easily and quickly that way. But it also, it looks at whether there's a type of technology or type of surveillance that is going to chill our associational and expressive freedoms. And I think this is the rule going forward. In the paper, I talk all about how this is a perfect example of living originalism with a nod to our friend Jack Balkin. I think it is. I think this is what the court is doing. It's trying to figure out a way to take old concepts, original principles from the Constitution and apply them in a way that makes sense for technology that the framers could have had no idea would ever come into existence. Thank you.
Thanks, and sorry to...
No, I'm sorry to take so long.
Okay. Susan?
All right, thank you. Audience members, virtual and real, gaze upon our panel. This is a group that is actually well prepared to answer the myriad questions that Jamil just posed, really asking us to come up with a test, a very detailed test, for addressing the many questions that the Jones decision left open. In particular, how does the Fourth Amendment apply to location surveillance when there isn't a physical trespass? For example, when the law enforcement agents use cell site location data, as Chris Segoyan was talking about, or when they use a remote turn-on of location devices, for example, when they use the GPS device that our cars have or our phones have. These are questions the decision left open. Another really important question the decision left open, is a warrant even required? Is probable cause required? All these questions the decision left open. And this panel is among some of the best situated people to answer that. Scylla has an article coming out where she elaborates on her second and third stories that we didn't really get to hear about, and her test. David Gray, along with the talented and brilliant Danielle Citron, have a series of articles in which they elaborate on their test. Priscilla, when she when she filed the brief for the Yale ISP, was good enough to include a test that I have worked out in some of my scholarship, detailing the 4 factors that I recommend that we use, that I can talk about in Q&A for surveillance, when surveillance should be subject to the Fourth Amendment. My 4 factors, I'll just put them out tantalizingly, are that when surveillance is hidden, continuous, intrusive, and indiscriminate, it should be subject to the highest level of Fourth Amendment protections. So there are other people who are doing good work in this area. Chris Slobogan. Oren has got work out in this area, Oren Kerr. All this work could be informing and aiding, oh, sorry, I forgot to mention Judge Kaczynski, who has already been complimented on his very eloquent dissent in the hearing from En banc and Pineda versus Morena, and has been at the forefront of very forward-thinking and intelligent and eloquent decisions about how to apply the Constitution to new technology. For example, just actually had a really important decision about the Computer Fraud and Abuse Act, comprehensive drug testing. The Ninth Circuit really benefits from Judge Kaczynski's analysis. And yet, I'm here to tell you a sad story, which is that all of this work is not getting into the courts. And the lower courts are not doing the important work of percolating the Jones test and figuring out how the Fourth Amendment should apply to surveillance, both directly applicable to Jones, in other words, following the Jones facts, and extending out from the Jones facts involving other types of location surveillance. And the reason for that is because of a decision that the Supreme Court issued the year before Jones called Davis versus United States. And in Davis, what happened was the Supreme Court considered whether or not let me just say it this way. The Supreme Court expanded the good faith exceptions to the exclusionary remedy. So everybody knows Leon, which says that if the officers rely on a defective warrant, the court should deny the suppression remedy based on the good faith reliance on a defective warrant. And the court had extended that to if officers rely in good faith on a statute that's later found to be unconstitutional, that's okay. We shouldn't penalize them by granting a suppression remedy. And what the court did in Davis is find yet another reason to deny a suppression remedy, and that is when officers rely on binding appellate precedent. So when the precedent at the time of the officer's conduct gave the officers reason to believe, basically, that what they were doing was legal, then even if that conduct is later found to be unconstitutional, courts considering motions to suppress based on that conduct later found to be unconstitutional should deny them. And so the Davis decision did two things. One, it was basically actually decided on the basis of an automobile search. And so it was based on a separate set of facts. In the case of Davis, the search, the court actually said that Davis, the search that they conducted in Davis was clearly unconstitutional at the time based on binding New York precedent. And so the actual holding of Davis, the narrow holding was when binding precedent specifically authorizes the conduct of the search, you should excuse the conduct in the sense of not granting the exclusionary remedy. But there was also a lot of language in the decision of the Supreme Court where the Supreme Court indicated its distaste for the suppression remedy. And it really was dicta, but it was a lot of broad language saying that the exclusionary remedy is not a personal right, and we should engage in a cost-benefit analysis where we weigh the cost to truth and public safety in granting the exclusionary remedy against the benefits to deterrence, which the court found were really not there unless the officers had engaged in sort of flagrantly culpable conduct. So going back to Jones, after the Jones decision, the Supreme Court remanded some cases and said, hey, circuit courts, figure out what to do in light of our decision with these surveillance investigations where the decision is still pending. And one of them was the Pineda-Moreno case. And they sent it back to the Ninth Circuit and said, what do you think? Do you think this surveillance should now be considered illegal in light of Jones? And the Ninth Circuit could have looked at the 2010 decisions, including Judge Kaczynski's dissent from rehearing on Bank, and said, well, Judge Kaczynski made some very convincing arguments about how the surveillance will take us into an Orwellian state, and particularly considering that 9 justices of the Supreme Court just didn't approve of this GPS surveillance, let's reconsider this whole question. And instead, because the government raised the Davis good faith argument, the panel said, let's look back at our precedents from 1999 and the 70s to figure out if, in 2007, when the officers engaged in the surveillance of Pineda-Moreno, they thought that what they were doing was legal. Oh, yeah, they did. And so that's an example of a narrow application of the Davis rule that shows you that in a case where the binding precedent in the circuit was applicable, the the courts will avoid thinking about how Jones applies. And so the Ninth Circuit said, Jones actually makes this conduct clearly unconstitutional, which we're not going to give any further discussion to. But once the cases get out from under the shadow of Jones, in other words, once the investigation takes place after January 2012, then we'll figure out what to do with Jones. So in the narrow application, we're delaying consideration of Jones for that several year period until the investigations took place after Jones was issued. Much more pernicious and that's pernicious and troubling on its own because, again, we have to wait several years to get the benefit of Judge Kaczynski's reasoning and the reasoning in the Seventh Circuit, which also had a very interesting decision in Cuevas-Perez that we won't get the benefit of. But more pernicious and troubling even than that is that courts are using the broad language from Davis to reach out beyond in circuits in which there is no binding precedent, to engage in this broad cost-benefit analysis, this focus on officer culpability, and say, well, we don't have binding precedent in this circuit, but the consensus of the law generally at the time tells us that we shouldn't grant the suppression remedy. And so in those cases, they're denying the suppression remedy. And what I should make clear, if I haven't made clear previously, is in cases where they're denying the suppression remedy, again, they're not engaging in the Fourth Amendment analysis. They're saying, why should we engage in the Fourth Amendment analysis? We're not going to grant this defendant suppression, and we don't need to get into constitutional issues where it's not necessary. Or else they're engaging in a very cursory analysis and saying, but this is dicta, so we don't want to spend a lot of time here. And so we're really losing the development of Fourth Amendment law, which, by the way, Oren Kerr predicted when he wrote several articles about the negative effect of Davis on Fourth Amendment law development and when he argued Davis to the Supreme Court. Most troubling is that courts are using a just ridiculously expanded version of Davis to apply it to location data that's not even involving GPS, and they're just completely untethering Davis from its facts. And an example of that is Jones on remand. And so on remand, the district court in the D.C. Circuit considered whether Jones could make a claim based on prospective location data surveillance. And the officers in that case got a D order, which no court really had approved of. You have to get either a hybrid order or a warrant. And the court, in analyzing this, said, I think there was good faith reliance on a warrant, and there was no warrant. I think there was good faith reliance on the statute, and the statute on its face wouldn't have allowed this kind of surveillance. Davis. And the court said, no suppression remedy here, and I'm not going to talk about the Fourth Amendment. Someday maybe we will. And if that trend continues, I think I have to stop, says my next door neighbor here. If that trend you wanted me
you have
something?
2 minutes.
Oh, I have 2 minutes. Oh, okay, so maybe I can slow down. If that trend continues, I have to read my signs better. If that trend continues, then Davis will be used to really inhibit the use of the Jones rule beyond the actual facts of the case. We will not have the benefit of the tremendous learning of this group and others like us. And I just want to say also, I did a preliminary look at trying to acquire some statistics. And when I say I mean me and my research assistants. And we found, this is just preliminary, I have to not massage, but I have to massage these numbers. No, I have to, no, I didn't say that. I have to check the work of my research assistants and make sure I'm doing the search right. But we did a preliminary search of lower court cases in the year post-Jones, where we looked at cases that cited Davis, Jones, and GPS. And we found 36 cases that fit that description in Westlaw. And of those, 30 granted the Davis good faith exception, 6 didn't. 32 denied suppression, 4 didn't. And we found that only 10 engaged in Fourth Amendment analysis. And I think that number's inflated because I don't think my research assistants quite understood what I meant. But at most 10 engaged in Fourth Amendment analysis. And some of those, again, were either just a standing analysis or, I think this is what is right, but it doesn't really matter because I'm going to deny suppression. So the Davis case is having a significant impact on the development of Fourth Amendment law. In other words, it's inhibiting it. And just lastly, I think this is really going to force us to think about the fact that the Supreme Court really doesn't like the exclusionary remedy. And if we want meaningful privacy rights, we're going to have to look elsewhere. But I haven't fully developed that idea, but I think that's where we're going. So really interested in your questions and in hearing from Judge Kaczynski.
Thanks, Susan. Judge Kaczynski.
Thank you very much. First of all, I want to thank Jack, Margot, and Christopher for inviting me here. I go to these conferences because I learn a lot, and I find I can better understand this complex world we live in technology when I attend conferences. Christopher and I were at a conference a 3 years ago, and that's when I first found out part of what he showed us today, and I then wind up citing in an opinion and sort of shaped my thinking about the area. And I read Susan's paper about Davis. I wish I'd read it a year ago. I
didn't write it a year ago.
Before Pineda Moreno came out of our court on remand, because I know I did not appreciate the significance of Davis, and probably didn't give the case as much consideration as I should have.
Maybe it's a good thing you hadn't read it. You might not have written that.
No, this is on remand. This is on remand for the Supreme Court. So this is very useful. I'm here mostly to listen, so I'm going to say very limited things. I'm going to try to stick to the 5 minutes. So I'm going to speak just narrowly about the one point that Scylla mentioned that was in Justice Sotomayor's concurrence in Jones, and that is the problem of a third-party doctrine. This is a huge, huge problem in this area, and I want to try to explain why, and why it's going to be so difficult to overcome and to deal with it. And if you go back and think about Katz and what happened in Katz, the Supreme Court adopts this rule, this sort of new principle of the reasonable expectation of privacy. And what they said is a conversation is private. Why? Because it's a telephone conversation, and he closed the door to the phone booth. It's really sort of significant as you start to think about it, because they look at the world and how it operates, and his conduct in the context of that world. There was a phone booth, and he closed the door. Now, think about what happened if the case happened today, right? The conversation would have happened on a cell phone with somebody yelling out and being able to hear this. So I'm not sure they would have had quite the same perception of how telephone conversations work. But anyway, they made the decision, and I think they're going to stick with it when it comes to telephones. But at the same time, they said, and not in that case, but in a sort of related series of cases, the information about the phone number, about what phone number he called, is not private. So the content of the conversation is private because he closed the door. But the phone number, he had to punch into the phone, or I guess in those days it was an actual dial into the phone. And by dialing the phone, he informed the phone company. And because they informed the phone company, it can't be private because he disclosed it to a third party. And that's what authorized pen registers. Does anybody remember pen registers and what they are? These are little devices that were attached to a phone line that would be able to figure out the beeps every time you or clicks every time you did a dial. So when you dialed a 9, it would click 9 times, and it would count how many times. So you could tell what phone numbers you called. And those things were considered, are still not considered to be private under the Fourth Amendment because they're disclosed to third parties. Well, the world we live in now is one where we constantly disclose information to third parties, often unwillingly. It used to be that you go into a store and you'd buy a book, and you'd pull out $5, and usually got change from that if you bought a book. And what book you bought and how much you paid for it was between you and the bookseller. And maybe somebody standing there near the catchers observing what you're doing, but that was it. Now you generally pay with you may buy it online, or if you don't buy it online, you actually go into a store. You generally don't pay cash. You generally use a credit card or a debit card. And that information gets sucked up by the credit card company. It gets sold to Expedia and the people that, what are the other credit reporting services? And then it gets aggregated. They wind up, and this I found out just in the last week or so. I was at another conference. This is why these conferences are so useful. I was somebody from the industry that provides content, and what they do is they now can tie your credit card to your set-top box. So when you are watching a program and it cuts to commercial, the commercial you get may be quite different than the commercial in the person next door watching the same program. So I said, how do you do that? He says, well, there are microchannels on your cable TV or satellite, and they will switch you to the cable, so they have different commercials running parallel. And if you are there at home, guys, and you get a Viagra commercial, it may be that, and this is exactly the example that the guy told me. He says, you don't know. Is it that they think something about me that I don't particularly want to disclose to the world? Or is it that everybody got a Cialis or Viagra commercial? Chances are very good you got that Viagra commercial for a reason. The reason this is so significant is the third-party doctrine holds, essentially, that the government can see anything you disclose to a third party. I mean, they are I think we don't acknowledge this often, those of us who are concerned about privacy. The government is involved in very important work. They are there to fight crime, they're there to root out child pornography, they're there to look for terrorists, they're there to protect us from all sorts of evildoers. So they are doing incredibly important work. I mean, we just want them to do it in a responsible way, but what their objective is really important. And what the Supreme Court has said in the third-party doctrine, if other parties, if you disclose information to third parties, then you can't say it's private from the government. And this goes back to a case from about the same time as Katz, a case by the name of Hoffa. Who here remembers Jimmy Hoffa? I saw him down the block just anyway, Hoffa was prosecuted. For those of you who don't know, he was the head or boss of the Teamsters at the time. And he was prosecuted by the government for various, the kind of activities that union leaders sometimes engaged in those days. I'm not saying he was guilty, but
Wasn't it
he was
Texas?
guilty, yeah, okay. Well, I don't know. The point is, and the way they prosecuted him, much of the evidence came from information that he himself disclosed to people around him, one of whom was a spy for the government. They planted somebody there who was present when he discussed all sorts of things, including matters that were of attorney-client, that would be normally protected by attorney-client privilege. And what the Supreme Court says is, look, you have a choice on choosing your friends. And if you happen to be dumb enough to choose somebody who then betrays you, too darn bad. You are not protected. Now, I don't know how you feel about Hoffa. I'm ambivalent. Well,
ambivalent.
I'm ambivalent about it. I think there's some logic to it. But at the very least, Hoffa made the decision. He trusted the stool pigeon, and he made the decision. He made the disclosure. He could have asked the guy, go away, and if he'd been suspicious enough, and I'm going to have a conversation with my lawyers, leave the room. He didn't do that, and at least he made what one might think is a reasoned choice about it. The problem is that much of what we do in daily life, we disclose all sorts of information to third parties, and most of us, even those of us who believe ourselves pretty sophisticated about technology, have no idea we're disclosing it to third parties and have no full appreciation, just the degree to which we're disclosing it. The business that Chris was talking about, until I heard him talk about it 2 or 3 years ago, it didn't dawn on me. Now, once he explained that, I said, duh, of course. How are they going to find you on your cell phone? They don't just guess. The only way they can find you is because you log into a cell tower. So, the way somebody in Paris or Tel Aviv can get a hold of you, even if you happen to be in Lubbock, Texas, or someplace like that, is your phone is constantly talking to the cell tower saying, here I am, here I am, here I am. And it's a very good thing because when you get a phone call, it can find you very quickly. If the phone didn't do that, you would miss a lot of calls. But you don't think about it until somebody points out to you that's what you're doing. And once you do, you become a slave to technology. Does anybody here not have, just raise your hand if you don't have a cell phone with you. Right. Okay, I ask the same question of people, and of course we can all be pinged. We can all be pinged, and we can all know where the great left-wing conspiracy is going on right here. Anybody here? How many people here? And then I usually get 1 or 2 hands. Right, doesn't have a smartphone. There we go. Okay. Okay. Usually that's about the sprinkling of hands I get in a group like this. And, of course, the smartphone delivers all sorts of additional information, as Chris explained. Not only the GPS information, and, of course, if you take pictures, it puts all that data in the pictures. And so the third-party doctrine is a really, really difficult hurdle because we disclose, and I'm going to just take 1 more minute to talk about why it is such a difficult problem. We could have legislation, for example, that says, look, go away, Experian. We're not just concerned about the government. We're not just concerned about the government. I think it's sort of creepy to have stuff funneled to me based on my purchases, or to have people relating to me in ways that are shaped by sort of how I Google, but it happens all the time. I find it sort of creepy. Doesn't matter if the government involved. I mean, even if the government is not involved, I find it sort of creepy. But I often ask myself the question: let's say we had legislation and Congress said, look, we're going to put a stop to all this stuff. It's just not going to happen. You can't do it. You just can't gather information. It doesn't care whether you're government or private. You can't gather information unless you get an explicit waiver. Well, there are costs involved. There are serious costs involved. The reason you pay as little as you do for your credit cards is that they sell this information to Experian. The reason this winds up subsidizing your cable viewing and so on, there's a lot of money involved in this. Google is free because they get ad data which is targeted to you based on your searches. And let's say we put an end to all of that. People would have to start paying for Google. People would have to pay for credit cards and all that. And I often ask myself the question, much as it bothers me and rails me, and I get, I'm not going to use the word, but I'm going to ticked off about it. That's the word. Would I be willing to pay $10 a month to avoid it? I think so. Would I be willing to pay $100 to avoid it? I'm not so sure. Would I be willing to pay $200 to avoid it? I think you're now coming to my price point. I think probably not. If it's $200 for the whole family, maybe. But if it's $200 for me and my wife and my 3 sons and my grandchildren, that gets real money. So the reason I think this is going to be very difficult to do is people are basically cheap. I mean, we've gotten used to getting the stuff on the cheap by selling our privacy. It's a deal it's a bargain we didn't start out making. It was made for us, but we've gotten comfortable with it. And I think it's going to be very difficult to get people Congress to legislate, for example, and say, we're going to put a stop to it. You go and start paying for it. I think people are going to rebel, and they're going to say, no, I want my free Google, I want my free email, I want cheap credit cards, and so on. And so long as we are willing to sell our privacy for that kind of price, which I think I don't think I'm being pessimistic here, but I think that's about the price point for a lot of people. I think that it's going to be very hard to complain that the government gets the same stuff that we're willing to sell so cheaply to third parties.
Thanks, Judge Kaczynski. I think I'm going to just make one comment / question of my own, and then open it up to you guys. So the third-party records doctrine, obviously, I think probably all of us, on this panel would agree that that is a real problem. But I also think that there's a relatively easy doctrinal solution to it, which is that rather than hold that merely by disclosing information to a third party you lose your constitutional privacy interest in that information, the court would just hold that the mere fact that you disclose information to a third party doesn't defeat your constitutional privacy interests. That would solve the problem. Now, it wouldn't solve every problem, because you'd still be left with the question whether in the specific case there was a reasonable expectation of privacy or not. But for that reason, I want to ask a question about the reasonable expectation.
Let me just make a retort to that, and let me just pose a question. So the government says, fine, we don't get it for nothing, but if Experian can buy it, we can buy it, and we're willing to pay for it. How do you stop them from buying it? Just like they're taking data from the phone company, right?
But buy it from the consumer or buy it from the third party?
Buy it from the third party,
Okay.
just like Cox does.
Make them buy it from me, and then I get to decide.
David, you want to weigh in on that? Or?
I do, because this is another problem that Danielle Citron and I have solved elegantly. And in our view, if the focus is on the technology and the capacity of the technology to facilitate a surveillance state, then we're not asking about the kind of information that's gathered or even how much information is gathered. We're talking about controlling access to that technology. And so if that's our focus, then the third-party doctrine is not the problem, or rather, to the extent it's a problem, the solution is the state agency requirement, which is to say that if a company like Google or a telephone company is so regularly a target of demands for information using technology that, if it were directly used by the government, would raise Fourth Amendment concerns, then that company has become a de facto state agent. And we would need to erect some kind of a legal wall between the government and that private entity, like a warrant requirement or an enhanced subpoena requirement, that would provide that would allow us to preserve that wall between public and private. It remains true that these private agencies might raise their own concerns, but by definition they don't raise Fourth Amendment concerns. And so those would be difficulties for legislation, but not difficulties for Fourth Amendment.
So I'm going to let other people respond to that, but I actually just wanted to ask, I didn't quite get to my question, which was, at least 2 and maybe 3 panelists denigrated the reasonable expectation of privacy test. And I'm wondering what we mean when we denigrate that test. Do we mean, do we think that this is a problem that in some way we're stuck with, or is the reasonable expectation of privacy test, is it like democracy? It's the least worst option. There are lots of problems with it, but we don't have a better solution.
Did I denigrate
Yeah, I
it,
don't think-
in your view?
Well,
I referred to this
I thought you
problem
did,
that
but-
lawyers have with understanding it. So that people say, well, it's a circular test because as soon as the surveillance is happening, then you must reasonably expect it to be happening, and therefore you've lost your expectation of privacy, which is just stupid in my view. I don't understand why people think that when it's clearly not about that, because the general warrants were happening, and so if that was true, you reasonably expected police to come in any time. So it's just a problem with lawyers being
The way we apply the
narrow-minded.
doctrine rather than- right.
Narrow-minded in
Right.
our interpretation of words.
Right.
Yeah, my problem with it is that it's really difficult for judges to do it right. And I think the reasonable expectation of privacy test, as it was originally applied and derived, required a normative assessment of the kind of risks we should be entitled to not accept, what we should be entitled to expect in our society, and that's how it was designed. And the problem is that judges, particularly today, are uncomfortable making those normative judgments, and so instead they look for shortcuts to avoid it. And the shortcuts they look for are problematic, like, for example, the third-party rule, or, for example, a non-content content distinction. And so, or for example, the one that Priscilla just mentioned, which is, well, this information is capable of being intercepted, therefore you don't have a privacy interest. And I think Jones is yet another example of, well, we don't like this reasonable expectation of privacy test because we don't want to face this normative question, so we're going to look for some kind of a shortcut. And I think this is why I came up with my 4-factor test, to try to give them something else to grab onto that is actually rooted in doctrine, that provides some elaboration of the test. But I think the test is asking a reasonable question, which is, and it's related to what David and Danielle are asking, which is, and what Justice Sotomayor came up with, which is, how do we balance law enforcement against privacy interests in a way that works in the society we want to live in? And I think the Supreme Court could come up with a different version. They came up with cats, come up with something else. I don't think they have to use that, but they have to solve that question in a way that works with the Fourth Amendment.
And in 2 sentences, I concur with these views, and just to say that the reasonable expectation of privacy test is a normative test, not a descriptive test. And so the question is, what's our normative expectation? It's not an exercise in autoethnography. Otherwise, we are doomed to what Danielle cutely calls technological determinism run amok, which I love that line.
I like ethno what?
Autoethnography.
All right, that's good too. If there are questions, I think we're going to use these mics. Is that the idea?
Yeah, there's the
Right.
line right there.
Okay, go ahead.
So this has been fantastic. I think this is really very interesting and really informs my criminal investigations class, is especially that. So in Jones, wiretapping was held up as a triumph of the way in which a legislative response to a Fourth Amendment problem was enacted. But it sounds like if we took Judge Kaczynski's view, you would just have a per se rule against wiretaps. Because, I mean, everyone, unless they're shouting into their phone, thinks the only person they're talking to are the people on the other end. So it would seem like they do have that reasonable expectation of privacy. And I just wonder
there's
if we
no
would
per
take
se rule against anything. With a warrant, you can get even into some of these matters.
Right. But do you need, or pen registers don't require warrants?
Pen registers don't require, they require something under the, I'm not an expert in this, constitutionally they don't require anything, I don't think, but there is a federal statute that governs them that does have a requirement. And Congress, in fact, has been quite protective, quite responsible, I think, in that area. But technology...
No,
With wiretapping, they have. I'm sorry, this is not... but they've simply been overtaken by technology.
Yeah, but just if I could, the pen register statute requires a rubber stamp court order, where the courts have said it actually is not, the courts are not allowed to engage in independent review, and they must grant as long as the facts establish relevance to the investigation. No, Judge Smith?
As long as the law enforcement officer certifies it's relevant.
As long,
And the magistrate judge has to sign off.
there we go. And there's no notice and there's no suppression
But
remedy.
that's not constitutionally required.
Right, exactly, no, because.
So
right.
Congress gave something more than...
But purely to gather statistics administratively. I mean, it's a joke of a privacy statute.
All right, fair enough.
It's obviously terrible of me, but I just thought there's this case in California called Gonzalez versus Google that I think has a lot of really interesting parallels with this problem, where a subpoena was served on Google to get 10,000 search queries. And of course, that's a canonical example of a third-party disclosure, so you'd figure they wouldn't need any sort of special, it wouldn't even be problematic, but the court engaged in a very interesting balancing test that seems to really mirror Silla's sort of concerns about associational freedoms and expressive freedoms. So
That was a district court case,
Yes.
if I remember correctly, and
That's
it went
where-
away.
It went away.
No, the only reason I asked, I can't talk about any pending case, especially a case pending in our circuit, but I am familiar with the case. My understanding is it went away, and, it's very commendable of the judge to have done that, I think.
Yeah, but that was a case where they were asking for information because they were investigating the Communications Decency Act, and it was sort of civil discovery. There was nobody who was going to be prosecuted, and they were investigating, and Google was avoiding it because they were worried about disclosing information about their trade secrets. And Judge Ware said that,
Well, so what's interesting is Google used the trade secret defense because they didn't have a constitutional, it didn't seem that they necessarily had a constitutional hook. So
and
they
the,
were
and the
using
judge had to analyze the case under the subpoena standard, which asked whether it was burdensome. And they said, yeah, it's burdensome because Google's worried that if their users find out that that the government's looking at how many porno searches they did, they may be upset. I mean, I think I think it's nice that Google resisted, but it's a little bit disturbing to see the subpoena standard being used to figure out whether all of our data should be exposed to the government.
Hey, let's not be critical. I think,
Yeah,
I thought, again, the case is over, so I hope I'm not counting the pending case, but when I saw it was very responsible for Google to have resisted for whatever reason.
I said that.
And I know Yahoo, some other search providers have not resisted in other cases. I'm not that familiar with all the facts, but it seems to me that if people became more aware of this thing, and if they discriminated on search providers, depending on whether or not they take a public stand in resisting such things, at least go to court and resist a subpoena. It seems to me Google ought to be rewarded for having taken that stand.
I don't
And
disagree.
people
I
ought
agree.
to switch to a service provider that resists away from ones that don't resist. Just as I think that the phone company, Christopher, what phone company is it that provides the website?
Sprint.
You know, the last
It was Sprint.
last time it was limited to Nextel or somebody.
Sprint was the first, and all the others followed.
Oh, okay. I was going to say when it was only Sprint, I was sort of happy to have AT&T. But it seems they don't get anything out of it by resisting, and it seems to me consumers ought to be trained to, ought to be taught, ought to be educated to reward service providers that resist.
I think that's absolutely right. And just on the subject, Google has been the leader of pushing back and requiring a warrant for stored content and in putting up this transparency report, which is very helpful. And Twitter has done that too.
Because at least it brings it before a judge.
Yeah.
I mean,
Yeah.
So I have a story and a question. In 2006, I came home after staying at a friend's house for the night, and my front door had been smashed open. And I thought I'd been the victim of a robbery. And I went into my home, and my house was chaos. I mean, there were papers on the floor. I mean, my house had been ransacked. And it was only when I walked into the kitchen and I saw a search warrant taped to my kitchen table that I realized that the FBI had been to my house and had searched through my possessions and taken some of my stuff. Now, in that case, the FBI got a warrant, and so they satisfied the warrant standard, and they obtained the warrant, and they actually woke a judge up at 2 in the morning to get a nighttime search warrant. But it was only because they taped the warrant to the table that I found out that the government had been rifling through my papers and files, and that I had, in fact, not been the victim of a robbery. In the digital arena, we don't have the automatic notice that one receives when someone searches their home, in that you don't see the evidence of the search. When Google or Yahoo or Sprint hand over my phone records, I don't automatically know. I can't see that they've been touched. And so we rely upon notice in another form to even tell us that this has happened. And unfortunately, through a series of interpretations by lower courts, right now the sort of built-in notice provisions in a Rule 41 search warrant are interpreted that the government has to provide notice to the ISP that hands over data, which of course the ISP already knows because it already handed over the data, and the individual doesn't ever get notice. In the context of ECPA disclosures of non-content data, like location information, you have no mandatory requirement for notice. And so my question to the panel is, yes, it's great that the government gets a warrant in the context of a Fourth Amendment search, but isn't it also important that at some point after the search has happened, that the individual be notified? And what do you think about the fact that either in the case of emails or location data, that we don't have automatic notice to the subscriber, the impacted subscriber at some point down the road?
That strikes me as a perfectly reasonable expectation to have, and balancing the competing interests between law enforcement and citizens in these kinds of technologically enhanced searches.
Reasonable to expect notice.
Reasonable to expect notice, yeah.
Yeah.
But once again, you have to ask the question. You don't get notice that when you swipe your credit card that Chase conveys information to Xperia, which then conveys information to Cox, which then can determine what commercials you get on your television. All that stuff you don't get any notice of that. Why should the government be in a worse position than commercial?
Because the government has the power to retain that power perniciously and has historically used that power, I mean, to target dissidents, to target journalists, to target, and Scylla provided great stories. And the government has a power that is much more dangerous than the power by corporate entities, unless they give that
Well,
information.
there's a reason that the government's subject to the warrant requirement and the private entities aren't, right? Which is what you're talking
It's
about.
called the Fourth Amendment.
It's called the Fourth Amendment.
Well, and the First
right,
Amendment
and there's
as
a reason
well.
for that. Yes, but I think the question would be,
Why don't you?
I think what you're asking is it constitutionally required in some way for them to give you notice? And so that's a harder question, right? So you would have to say, well, is there some requirement on the Fourth Amendment that you have noticed that a search has been conducted? And if I don't know the case law well enough to know whether they had to tape it to your, do they have to tape it to you? They
Yeah,
do,
the
right?
Fourth
So
Amendment, yeah.
if they do in that circumstance, I don't see why you couldn't make the argument that they have to give you notice in the computer context as well. And I guess it's this problem of they're searching the ISP, right? And so we have to make that connection somehow in the litigation in order to enforce that notice requirement through the ISP to you. One of the interesting things, and I'll just say this about the physical trespass ruling in Jones, is that I think there's no reason that the physical trespass doctrine can't be extended to sort of digital invasions of property, right? I mean, if Justice Scalia can make up the tiny constable who hides in your coach, your extra large horse and buggy, in order to create some sense of physical trespass in the founding, I think you could also think of tiny constables going through wires in digital or even wirelessly and invading your computer and trespassing in that way. So there may be a way to extend the physical trespass theory of search to wireless or digital searches, although certainly if you look at the court's opinions, they don't see it that way now. But maybe with more education about what actually happens digitally and how your private property gets taken over really physically by code or whatever, however that works, maybe they would change their minds. But the reason I mention that here is because I think by extension, one could try to make that same kind of argument in trying to extend a notice requirement in physical warrant stuff to digital searches as well. And you could try to use that. That's just off the top of my head where I would try to go with it if I was litigating.
Okay. Let me just make this point because I think it's really important. A couple of panelists said, "Oh, it's because the government. The government has constraints because it has governmental power." Let's be very clear about this. The government only needs a warrant to do things that you as a private person couldn't do at all. You as a private person can't go into somebody's home, no matter how badly you want it, and break in lawfully and do what they did to Christopher. Can't do it. So when they try to do something, exercise a governmental power that they can't otherwise do, they need to comply with the Fourth Amendment. But let's say, for example, they suspect that Ralph's supermarket is being run as a front for an illegal drug operation. And what they want to do is they want to come in and go up and down the aisles and look for suspicious activities. They don't need a warrant for that because that is activity that you as a private person can do on your own. So when they do things like gather information that the credit companies and Expedia and Cox and Google and Amazon and all those people gather for nothing, I don't see why they can't say, look, we are doing important work. We are no less entitled to this information than private parties.
Because Judge Kaczynski, when the Berger case was decided and the Katz decision was decided, wiretapping and bugging by private parties was rampant. Rampant. And the Supreme Court said that you cannot engage in that without a warrant. Neither a private party, well, they weren't considering private parties, but the cops cannot engage in that without not only the warrant, but a whole lot of other protections, including notice to the target. And then when the Congress legislated in 1968, they made it illegal both for cops to do it without a warrant as well as other protections, and for private parties to do it. So things may be illegal even though they are possible. And one thing we're trying to figure out right now in the courts and a set of private lawsuits is whether or not some of the things these private entities are doing, whether it's Google or Facebook or what have you, are themselves violations of the Wiretap Act. So it's not enough to say that this information gathering is being done by private entities. It's still possible that it's a wiretap. And Priscilla asks about the case law. The case law establishes that when someone, whether it's the government or a private entity, is engaging in electronic surveillance, and we just have to figure out what that means today, what is the modern equivalent of wiretapping, then that should be subject to the protections of the Fourth Amendment at the highest level, which include notice. And it should happen at the constitutional level, and it should be part of legislation. And I just want to commend the work of both Chris Segoy and Judge Smith on the importance of those kind of due process protections to having our rights effectuated. And one reason is, without that, we have the Justice Department going in and getting these crazy interpretations of the statute that for some reason dispense with notice, even though Rule 41 clearly requires it.
I want to get one more question from the floor, so Catherine.
Hi, I'm Catherine Crump. I'm a staff attorney with the ACLU. When Jamil started the panel, he listed a number of questions for the panelists to address. And one of them was, what, if anything, is the significance of efficiency to the Fourth Amendment analysis? When I think about what practically is happening here, right, it is that the practical barriers to surveillance have fallen, and it is now simply easier than ever before for law enforcement agents to engage in surveillance. That hasn't necessarily been helpful in the legal analysis, because there's case law that suggests that the mere fact that there's a technological enhancement to surveillance doesn't mean there is a Fourth Amendment problem. But I'm just curious what the panelists think about what room, if any, there is to argue that it is relevant as a Fourth Amendment matter that surveillance today is easier than ever before.
So from Danielle and I's point of view, that's precisely the issue, is that certain technologies provide for efficiencies that go so far as to raise the specter of a surveillance state. And when you're dealing with that kind of a technology, that access to that technology and use of that technology should be constrained by Fourth Amendment reasonableness. And just to go slightly parenthetically to that question, another benefit of this approach is that it shows exactly why Jamil was quite right in Clapper to argue that his client had standing to challenge the 1881A, 1881A, which is to say that if the real Fourth Amendment interest here is an interest of the people not to live in a surveillance state, and the Fourth Amendment stands as a bulwark against that surveillance state, then we each of us have an equal interest in our security as against the rise of a surveillance state. So certainly somebody well situated like the ACLU or individual members of the ACLU could say this is the kind of excessive access to a technology that's capable of facilitating a surveillance state that should be subject to challenge, which is to say they should be able to challenge the legal structure that purports to constrain governmental access to this kind of technology. And it's important from our point of view that the challenge there is to the structure, not to the individual use. Because when we're talking about guarding access to and use of these kinds of technologies, we're quite open to the possibility that there might be a pat policy that could be replicated in a number of different law enforcement agencies in a number of different circumstances that would be per se constitutional. That's sort of what we've done with the warrant requirement. As long as somebody gets a warrant, there is a strong presumption of reasonableness as to any search under that warrant. So too, we think that if we were to get to the substance of 1881A, and the Supreme Court were to say that that sounds like a perfectly reasonable balance between the competing interests of law enforcement interests and citizen privacy interests, then that would be it. But of course, we can't get to the substance because the court is quite wrong-headed about the standing issue.
I just want to say, I think efficiency, remember I have my 4 factors. They're hidden, continuous, indiscriminate, and intrusive. And I pulled these 4 factors out of the analysis the court did in Berger, and then the analysis that the appellate courts did in the video surveillance cases. And I think efficiency comes in terms of indiscriminate, that the easier it is to gather up a lot of information about a lot of people, the more that the judiciary needs to come in and exercise oversight over a law enforcement function. So I think efficiency is important in raising the stakes for a law enforcement technology, or for a surveillance technology, and I agree with Justice Sotomayor's discussion of that, and I agree with David's and Danielle's discussion of that too.
Right, and I agree. I think it's, efficiency is great, but efficiency breeds abuse and overuse, and that's exactly what that's the concern the court expresses in Jones, in the concurrences.
It's actually the other way. Efficiency creates abuse. I mean, the more efficient. I mean, sometimes you want government to be inefficient.
Yeah.
And as Justice Scalia reminded us at the beginning of Maryland versus King, that's the whole point of the Fourth Amendment. It creates inefficiencies.
Yeah.
So as conference organizer, we're going to push this 5 minutes into coffee break. Apologies to everybody, so that I can ask the question. What are your thoughts about, and what is the significance of Clapper v. Amnesty?
I think we start with Jamil.
Well, so
Were you persuaded?
I was persuaded of some things. Yeah, not. So I actually think that the Clapper, it's about standing. It's a question about who can challenge government surveillance programs that are conducted in secret, and the answer of 5 justices is, they don't put it this way, but is essentially no one. That a statute that allows the government to engage in surveillance in complete secrecy is a statute that is not susceptible to a challenge in a federal court. And so if you think of it that way, some of the same issues that Susan was talking about on the exclusionary rule, sort of on the back end, come up at the front end, right? It's just this question of how is it that the courts are going to engage the question of whether these surveillance activities are constitutional or not, if you have all of these barriers, both at the front end and the back end, to the courts actually reaching the merits. And to some people, I guess it's not, it doesn't seem like that big a deal that the courts aren't going to reach the merits of these constitutional questions, because I think to at least some justices on the Supreme Court, national security really does and should, in their view, exist beyond the reach of the kinds of constitutional claims we're making here. And by beyond the reach, I don't just mean that they will decide against us on the merits. I mean that they will not actually adjudicate the constitutional claims. They think there's something inappropriate about the courts adjudicating constitutional challenges to national security policy. So I think that Clapper is, unfortunately, very significant in the national security context. Whether it's going to have any implications outside the national security context, I don't know, and maybe the panelists have theories about that.
Let me just say, I think it's a disturbing decision. I worked actually with the EFF on the brief in the Hepting case, where we amicus brief, we argued that the judiciary has to get involved in figuring out whether these electronic surveillance programs are constitutional, because, and I hate to be U.S.-centered about it, but it's necessarily true that U.S. persons are being swept up in this surveillance, and there has to be a way for that to be reviewed. And I just want to make a pitch for a paper I'm working on. It still needs editing, but it's on SSR.
I'll read anything you write.
Oh, that's lovely. It's called Reforming Surveillance Law, and it's about a comparison of the U.S. to the Swiss system. And one of the things that we found, I worked with a Swiss lawyer, is that on the Swiss system, they don't allow their police to engage in a surveillance practice until the legislature has regulated it. And so when new techniques come into being, whether it's locations tracking or license plate recognition, the officers can't use it until the legislature enacts a law that regulates it. And we have the opposite system. Our system is officers can do anything until they're stopped. And what this means, the more that the Fourth Amendment is not brought to bear on practices, as we're seeing now at Davis and as Clapper indicates, the less that law enforcement is regulated. And I think that those two things together are very troubling, particularly because Congress, for some reason, finds it difficult to legislate on these issues. So I put those things together to just say that there's something wrong with our system, and I'm troubled.
So I'm going to be giving a talk at Georgetown later in the month, marrying a paper that I did on Davis and some of this work that Danielle and I have been doing on quantitative privacy. And the point that I'll make there and just make briefly here is that the Fourth Amendment doesn't prohibit searches, right? It doesn't prohibit searches at all. What it prohibits is unreasonable searches. And the court has told us quite wisely that reasonableness here, it requires a balancing of the competing interests of law enforcement and citizens, which is to say that the substantive right under the Fourth Amendment is inherently linked to the remedy. And the remedy comes both at the front end, in the controls on use and access to search, and on the back end for punishment of violations of that prohibition on unreasonable search. And the court has done tremendous damage on both the front end and the back end by repeatedly, again, on both the front end in Clapper and the back end in Davis, telling us that Fourth Amendment rights are to be considered separately from the remedies. The remedies have nothing to do with the rights. And it's quite the other way around. In the Fourth Amendment, the remedy is the right. And both in Clapper and in Davis, the court has gutted the Fourth Amendment because it has failed to take account of that fundamental difference between Fourth Amendment rights and other constitutional rights.
Any final comments from the panelists?
I haven't read Clapper, and I probably have to construe it, so I'm going to say nothing about it. But I've
Start with the dissent.
You clearly don't have an academic spirit. The less you know, the more you should say.
Yeah, but things you say today will get you accused tomorrow. So I can only say that I've listened carefully to what the other panelists have said on Clapper, and I will give it due consideration if and when I'm called upon to construe it.
All right, let me just thank then all of the panelists for their insightful remarks about this topic.
Thank you.